everyone, and thank you for joining us this evening. And a special thanks to you, Kenneth, and your team for joining us and doing this webinar with us. Before we begin, I'd like to hand it over to our Executive Director, Alexandra, here at ASO to tell us a few things about our organization.
Thank you, Carmen. I'm glad everybody is here to join us tonight. I'm sure that it's going to be an engaging and informative evening for us all. I'm going to just spend a couple of minutes giving you a bit of an introduction to who the Asperger Society of Ontario, or ASO, is. So founded in 2000, the Asperger Society of Ontario, or ASO for short, has remained the only nonprofit organization in the province, offering free individualized services, resources, and support to meet the unique needs of what used to be known as the Aspergers, but is now recognized as Autism Spectrum Disorder Level 1, or ASD1 community. Each year, we support thousands of people from all demographics and socioeconomic backgrounds across Ontario through a number of free services, like our Action Line, which is a free helpline for anyone with a question, need, or concern related to ASD1. So what does that look like? Well, we may get a phone call or email from an adult with ASD wanting to know how to ask for an accommodation at work, or maybe from a teacher looking to access some resources to support ASD students in a classroom, or a teen with ASD looking to connect with peers in a safe and inclusive space, or even a parent who's concerned about how to map out a financial strategy and plan for lifelong care for their child. And then we do our best to help, whether that's by connecting someone to an ASD employment program, sharing toolkits and resource guides, linking families to counseling services, working with amazing community partners like Ken Pope and his team here in order to get information, strategies, and tools into the hands of everyone who needs them, or sometimes even just by simply listening. At ASO, we do our best to understand the specific needs of everyone who reaches out, and then we explore resources and services and find ways to help each individual however we can. We also offer some free social and support groups. So we have a peer connections group, which is a virtual fun monthly hangout for adults with ASD 18 and older to connect and build friendships. We have Dungeons and Dragons gaming groups for kids and adults alike. We have a Toastmaster Youth Leadership Program to help develop communication and leadership skills. And of course, our family support network, where we bring together parents and caregivers across Ontario every month, just like this, to learn more about topics of interest, to share personal experiences, and to build supportive relationships. So whether it's in small ways like providing social programming, or in bigger ways like offering direct support in a crisis situation, we really try our best to offer meaningful, valuable help that makes a difference. And just in case all that isn't enough, behind everything we do is a constant effort to work with, not just for, the autism community, ensuring their voices are what's driving the development of services and supports, and working together to advance our mutual goals of greater understanding, acceptance, and action that leads to great things. That's a little about what we do, but how do we do it all? Well, with the help of an incredible all-star team of phenomenal volunteers like Carmen here, who gives her time every month to facilitate our family support network meetings like this one. ASO actually only has one staff member, and you're waiting for her to stop talking so you can get on with this webinar. And we actually operate on a shoestring budget. We don't receive any government funding. We rely completely on donations and fundraising events to support all of the amazing work that I talked about tonight. So if you would like to see more programs and events like tonight's webinar, I really encourage you to make a donation to the ASO. It's only through the generous support of people like you that we're able to do things like this. So if you'd like to learn a little bit more about our organization, if you'd like to support our work, or even join our volunteer team, I invite you to visit our website, which is www.asontario.org, or to connect with us by email at info@asontario.org. I'm hoping that we can put our website and email address into the chat for you for your reference. So please connect with us. We love to have your support, either your financial support or support in terms of time volunteerism. We're always looking to grow our team. thank you for your patience. I'm looking forward to learning a lot with you all tonight from Ken and his team here. I will turn it back over to Carmen.
Thanks, Alexandra. So tonight, as mentioned, we have with us Kenneth Pope. So Kenneth C. Pope is one of the most experienced practitioners in Ontario, providing services to families with a family member with a disability, and has focused his practice to help them put in place Henson trusts, which ensure that the child with a disability will not lose provincial disability benefits as a result of their inheritance. He also acts on behalf of clients to deal with the Canada Revenue Agency to backfile disability-related tax credits and recapture substantial amounts of taxes which could not have been paid, or which should have not been paid. So recovered amounts are typically between $16,000 to $22,000. His goal is to ensure that his clients will be able to plan effectively for the future of their family members. This includes the use of trusts for family members to minimize tax payable on income earned from inheritances. With 36 years experience, Ken's clients benefit from his knowledge and foresight. Ken's practice extends across Ontario and into other provinces as well. He frequently makes trips to present seminars to those who need his service but live outside of the National Capital Region. He has been helping families to think through their future needs and to provide for families with appropriate arrangements since 1980. In his practice, Ken Taylor makes solutions so that all his clients can take care of these important responsibilities and enjoy peace of mind. His knowledge and experience with estate planning offers his clients the full range of options suitable for their situation, all provided by a single source law firm. So thank you very much, Ken, for joining us and doing this, and I will hand it over to you.
Thanks very much, Carmen. I appreciate it. I'd like to say hello to everyone. There's 413 people attending so far. We had 705 registered this morning, which is a common type number for these events. And you can see my team here with me, and I'd like to introduce you briefly. You'll see Peter Zakar and Diane. Where is Diane? Just scroll down. There's Diane Moreno. Peter and Diane are my associate lawyers, and they will be speaking this evening as well. I'd like to introduce Jennifer Clark and Ziyang Shin. There's Victoria, there's Karen Christie, and I think that's everyone. So most of the people that you see right now will be turning off their video and muting their screen so that they can answer questions in the background. You'll see that there's a question and answer box. You're quite welcome. You're invited to ask questions. You can be anonymous. You'll see if you go into the chat on the Q&A. And we'll do our best. We won't be able to answer everything. And of course, we may not be able to answer your specific question, but what we will try to do is answer questions, especially ones that we think other people that we know, other people would like the answer to, because it's their question just as well. As far as more detailed assessments, you could register on the website. You could fill out the family evaluation form that's under contact on the top right. Those are received by 3 of us and processed so that we can do an initial assessment of your particular situation. Everyone who registered will receive this recorded video and the PowerPoint slides. So if some of the slides you can't quite make out, you'll be receiving them once this is all over. And that'll go to everyone registered. You should feel free to pass it on to other people if you wish. And you're now on a newsletter list. You can always unsubscribe, if you wish, but you'll receive notices and occasional emails of things that we find are useful for our clients. There are over 13,000 people on that list, so you're not crazy and alone if you happen to remain on. So this is my smiling face, sort of smiling, speak of. And the first thing I'd like to do is to put some context around the situation. We're in the process of getting updated numbers, but these stats are from ODSP. And you can see there on the top right there from February 2020. We're just now in the process of getting an update. And they will be slightly higher. The numbers will be slightly higher. And to give this context, it's approximately 1 family in 10, 1 household in 10 in the province that is the parent household of a child with special needs which is not a small number. What other single demographic is there that's 1 in 10? Very interesting. And the parents that are assisting their kids with special needs, they're often just too busy, very busy with their lives. Almost always, when an appointment has been made with the office for some purpose that has to be canceled, it's because we know that something has come up with their child. That's just how it is. So you can see by looking at the numbers that if you take the population of the province and then divide it by 3, which is what StatCan says you do if you want to know the number of households, you'll see that there's approximately 4,566,000 households. And if you then look just at the number of people that are on ODSP, the 378,000, that's just from ages 18 to 65. If you include the people under 18 and the people over 65, that's about another third. So if you add another 100,000, you can easily see that the number of households is 1 in 10. And if you were to then look at, okay, who else has an affinity for this child, this adult person perhaps? Well, it would be a sibling. It might be the spouse of a sibling. The very simple expansion of the linkages to people with special needs is very easy to do. And you can see that it rapidly increases the number of households that are concerned about that particular person to easily probably 1 in 5, 20%. And this is just ODSP. This isn't long-term disability or workman's comp or any of those things. You can see, I want to comment here in passing because I'll be referring back to it. On the right-hand side, all family structures says borders, 48,233. Those are all the people at home with family, 18 to 65. It's about 14% of the total. So when we start talking about ODSP benefit increases and caregiver tax credits and so on, you can see that some of it relates primarily to the 48,000, which is a high number to start with. But if you then also look at the 378,000 households that, as of 2017, can use the caregiver credit and don't know about it, these are significant numbers. This is a simple breakdown. My friends at the ODSP stats section tell me that they're going to give me new numbers here that are slightly more divided and clearer. For example, I requested numbers on the autism spectrum. Now, some of these are categorized under one thing rather than another when there's a dual diagnosis. So it doesn't tell all of the truth, but it gets us closer to understanding the situation. You'll have time to take a longer look at these slides when you get them. And these are the numbers by city, by region. You can see here Ottawa, 25,496. This is the number of benefit units, as they're so called. Here's the number of people in those benefit units. This would include spouses, or it would certainly include children. And then here you can see assistance for children with severe disabilities. It's not the severity, it's children with disabilities under 18 who are in a household with a household income of less than 45,000, which would be a lot of single income households. But it doesn't include all the other households with kids under 18. And if you look at this very quickly, if you understand that the sign on the highway coming into Ottawa says a population 1 million, that's therefore arguably 333,000 households. And you can see that you could easily gross up this 26,000 number to 33,000, and there's 1 in 10. Karen, are we getting very many questions coming through? Are people asking questions? I only see 8.
Yeah, we've been answering a few of them. Some of them are coming in from an anonymous that I can't exactly answer online because I don't know the whole situation, but yeah, we're getting there.
Okay, good. I see we have 424 people registered. That's the top number. That's 4/7 of those that registered. That's about what you'd expect. First point here, this is the part that Karen Christie deals with specifically, is benefit increases. The evaluation form asks the 14%, the 48,000 people, households that have their child at home, how much does a child receive? And initially, they're all receiving $896, which is the room and board amount. Everyone here with a child at home knows exactly what I'm talking about. They should also know that if their child has a modest or greater ability to shop or cook, that we may well be able to get them get their benefits increased to $1169. Now it's only $273 a month, but we've done this hundreds of times. And when I looked at it a year or two ago, I did a simple calculation, and with only those families where we've gotten them this increase, if you tally it all up, we have increased the income for their children as a group by $1,666,000 per year, which is fine, which is an excellent thing to do, I think, and it's a very good start. We'd like to help more families. So if you have a child at home with you that's getting $896, you should fill out one of those evaluation forms and tell me whether he or she can shop and cook to what degree. Another big thing that we do that also Karen and Victoria do is disability and caregiver tax credit recaptures. We'll get into more detail. But the first two things we do typically, people contact us, perhaps the motivator initially for them is they'd like the peace of mind that comes with having a will and a Henson trust set up in the will for their child. But what we do first is we try to see if we can put money in their pocket. So we try to get them a benefit increase. Our fees are contingent on success. And we also try to make use of the disability and caregiver credits if they're not being used, or if they were used and now they're not, or if they haven't been used for the full period or for the proper amount. And what we find in many cases is that that we can recapture about $16,000 for the caregiver credit, disability credit, and $10,000 for the caregiver credit. And in many cases, this is a full recapture of both of those for the family. It's not uncommon at all. In other cases, we can only recapture up to $4,000 or $5,000 at this point, because until 2017, the child had to reside with you. But what happened in 2017 was the reside with criteria was removed. So now, instead of applying just to the 48,000 that I referred to that are living at home, it applies to the whole 367,000 in most cases. The caregiver credit would apply to everyone. So if you'd like to know more about that, let us know. But again, the way to do this is to fill out that evaluation form so we have a better picture of the real situation. Also, as everyone here knows, I believe, and of course anyone with a child over 18 does know, that if your child is restricted due to their disability and at the simplest test couldn't function in a competitive workplace, then they may well qualify for the provincial disability benefits of these two amounts, of one of these two amounts, plus drug and dental coverage. And there are, of course, other things like food supplements and special diet and transportation and so on. But this is the basic program. And the amount that that child could receive in traceable gifts, let's say, if you're making automatic payments into their bank account, for example, or if someone wants to give them a gift, a grandparent, for example, they could receive and have $10,000 over 12 months. So it's the 10,000 over 12 month rule, but that's just for gifts that are, and normally people would give someone cash if that's appropriate. And it's not common for anyone except parents, for example, to give someone $10,000. Up until September 1st, 2017, it was a $6,000 gift rule, and it was also a $5,000 asset test. It's now $40,000 per individual, which is a much more functional amount, because it was, comical. People, they knew they could receive 6,000 over 12, but they could only keep 5. So I'm not sure what the internal coherence of that was. This is the criteria. This is rather the application process for the disability tax credit. And what it does, of course, is, aside from reducing taxes for a tax-paying parent or perhaps a brother or sister, someone who helps to some extent with the necessities of life, food, shelter, clothing to some degree. And even if you haven't in the past, you could always start, and it would reduce your taxes by about $1,600 a year. And it would allow the person, the child who qualifies for the credit, which is then transferred to you because you help with necessities, it would allow them to open up a registered disability savings plan. And of course, we'll come to that in a moment. And the line to look for, if you think you are using it for transferred from a family member, is line 31800. And if you're checking for the caregiver credit, it's a 304 line, 30425 or 30450. So, you know, we often, when people fill out the form, quite often they'll say yes, yes, because they're confused. They know they're using the disability credit, and they think that that's perhaps the same as the caregiver credit. But it's not, it's a separate tax credit. How much did we, I think it was, forget the total that we achieved putting back into the hands of family last year, but it was very significant, hundreds of thousands of dollars. This is a slide dealing with the caregiver credit. And unlike the disability tax credit, which must be approved by Canada Revenue after you've filed a T2201 application form completed by a doctor or signed by a doctor, because when we assist with the process, we prepare the form and you present it to the doctor, and the doctor looks at it and signs it typically. Because, you know, obviously what we say is true. Sometimes we have to have an anecdotal story page so that even the doctor fully understands, because often they see the client as a patient when they're at their best, and only when they're at the best sometimes, and they don't live with the child, so they don't really truly understand. They're doing their best. It's not that they're not, but you know, they need to be educated on what it is that would qualify rather than what they think wouldn't. So I think you've all had time to look at that slide. So then what happens is, if the child is approved for the disability tax credit, then they can have a registered disability savings plan. And as you can see here, if you take the circumstance of a child who's 18 or older, then the grants and bonds that the federal government would contribute are based upon that child's own income, not your income, even if they're living with you. And so as a result, since they're on ODSP and they get either $896 or $1169 a month, which at the maximum is about $14,400, the child would every year, regardless, receive a $1,000 bond for 20 years. And if the parent contributed $1,500, which the disability credit reduces their taxes by $1,600, so it's essentially a self-funding savings plan, then if you put $1,500 in, based upon the child's income, a further grant of $3,500 is paid in. So $1,500 in and $4,500, $6,000. Now, the interesting thing about this is that if you did this regularly, starting at age 18, just as an example, because this is the most common scenario, then if you put in 1,500 times 20, and the government puts in 4,500 times 20, that's 30 and 90. And if it was invested at 5% for that whole 20-year period, and then you stop contributing, although you could contribute more, you've got another 170,000 of room to contribute if you want to. But of course, most people don't have 170,000. If you leave it there invested until the child turns 60, then you'll see from the next slide that it accumulates to about $700,000. And now it's a wonderful plan, but it's intended as a sort of a retirement plan, because you have to contribute for 20 years and then wait for a further 10 before all the grants and bonds are vested. Otherwise, any withdrawal you take out will, again, you'll lose the grants and bonds are related to that number of dollars. So you're starting at age 18 and contributing and waiting for 30 years. So now the child is 48, 49, let's say. So you could start to withdraw then. But the idea is that it's to accumulate until they're 60. And then what happens at that point is the most common planned arrangement, although there are alternatives, is to start to pay out over a 23, 24-year period at a rate of about $30,000 a year. So at age 60, of course, the child is no longer a child, but they would continue on with ODSP at age 60, receiving also the $30,000 a year, which would not affect ODSP. And then at age 65, they become a pensioner, and they start to receive old age security and guaranteed income supplements, which is the state of affairs right now for the largest number of people with disabilities ever in Canada, because last year was the peak of the baby boom turning 65. And of course, age 65 boomers have people with disabilities within that cohort. So the largest number of people with disabilities turning 65, and all other people just turned 65 last year. This is that chart that shows the accumulation up to about 700,000. There are 2 or 3 different calculators like this online that you can get, and you can vary it and say, well, if I contribute this much and it earns that much, how much will it be? It's quite interesting. This is just a slide about the procedure for making determinations. I won't spend any real time on that. And similarly, these are some of the other ways that money could come out. For example, if the child has a reduced life expectancy, you can see that obviously there may be some other arrangement for that. I'm just going through my slides. All right, we're just coming up. This is the point where I'm going to say a few words and then turn the microphone over to Diane. Diane's going to discuss the situation where a child is competent, or perhaps borderline competent, incompetent, or clearly not competent. So the next slide that I'm going to go to is taking control. What's the difference? Diane, would you care to say a few words?
Yes, thanks, Ken. So I'm here and I'm just going to talk about what we call substitute decision makers. And there's 2 ways that we appoint substitute decision makers here in our law firm. We do powers of attorney for clients, and we also do guardianship applications. And Ken, if you could go to the next slide.
Yep.
So everyone is going to be getting a copy of these slides. So I'm not going to read everything that's on the screen right now, but this just covers what power of attorney for personal care is. And essentially, when a grantor grants an attorney for personal care, they're allowing that person to have the ability to make decisions over their health care, what the grantor will receive, who will decide where the grantor lives, how they dress, what you eat, etc. And can you go to the next slide, please?
Okay.
And this next slide, again, you'll have a copy of this, so I'm not going to go in depth, but this talks about what a power of attorney for property is. And when someone appoints or a power of attorney, that attorney for property, that attorney has the ability, again, to make decisions to pay a grantor's bills, to access their accounts, manage their mortgage payments. And here we're just talking a lot about finances and assets. All right. Okay. This slide talks in general about what a substitute decision maker is. And like I said, the two ways that we appoint a substitute decision maker here is through guardianships and a power of attorney document. Okay, and so this slide talks about guardianship. Now I'm just going to talk a little bit about the difference between guardianship and powers of attorney. And just some of the big differences. One is, what does it mean in terms of decision-making ability? With a power of attorney, when someone grants a power of attorney, that person, the grantor, still has the ability to make decisions. With guardianship, however, that the person is found to be incapable of managing either their personal care or their property. And this is why guardianship is needed. So when a guardianship is granted, that means that this person is not able, the allegedly incapable person is not able to make decisions. One of the other differences between powers of attorney and guardianship is how much work is involved and how much paperwork. So with powers of attorney, you're looking at about maybe 6 to 10 pages. The process is fairly simple. You have 2 witnesses, you have the grantor, you date it, you sign it, that's done. With guardianship, the way that we do it here, it's through a process called summary disposition. And that is a guardianship in writing. So everything's in writing. There is no in-person attendance from myself or my clients. The guardianship application is probably about maybe 120 to 200 pages long. But you got to remember this is double spaced and it's also printed on one side of the sheet, so it's not double-sided. So, and there's also a lot of information that it includes. First, we're going to include affidavits from the applicants. And in those affidavits, we're going to include reasons why these people are applying. Most of our guardianships are, parents that are applying maybe with their oldest sibling, and their guardianship application is pretty straightforward because we're taking someone who has been making decisions all their life for their child since birth. And after guardianship, they're still gonna keep making those decisions. The only difference is when you get guardianship, now you have legal authority to do it. So our guardianships talk about why these people are applying, why they're the best persons to apply. There's a long-standing relationship between them and the allegedly incapable person. It also includes 2 plans. One plan is called a management plan, and this goes through the financial aspects of the allegedly incapable person. And the other plan is called the guardianship plan, and this goes through the healthcare details of the allegedly incapable person. And again, the information that we put there is, we ask questions and we provide answers as to what you're going to do after you get guardianship. And in our case, even though it's more paperwork, it is still pretty simple. The process is still pretty simple because as an applicant, you're going to be answering questions that you already have the answers to. So in most cases, our applicant parents, already have established relationships with the healthcare providers, with the financial advisors. So, in terms of being able to handle this person's life after they get guardianship, it's second nature to them. And then the other thing that we also include are consents from all the applicants, because every applicant has to consent to their own application. And then we have some court prescribed documents. And then the last piece of this puzzle is we have to include evidence to that person's capacity to manage their affairs in both personal care and in property. And that's a big difference with the power of attorney. So these assessments this medical evidence that we put in the guardianship will say whether or not this person lacks capacity to manage their affairs or their, in both personal care and property. And that's why this necessitates that guardianship is needed. In terms of what happens after the guardianship is submitted, well, the court reviews it. And then there's something called the Office of the Public Guardian Trustee. They review every single guardianship application. Some of the questions I get from my clients are, when they review it, what do they ask? What do they look for? And because we've been doing this for a long time, a lot of the things they look for, we already have in the guardianship. Public guardian trustee, they like looking at finances, but if you can imagine, most of our clients, if they're applying for their child who has only ODSP income, most of the time it's the assets are ODSP, an account, a checking account where the ODSP goes into, and then an RDSP account, and probably no other account but those two things. And I don't anticipate the court or the public guardian trustee asking many questions about that. And if they do, we already have answers in the guardianship to address anything that they might have questions about. Okay.
Okay. When you've finished your part, I'd like to make a few comments as well. So just let me know when you're done.
Can you go to the next slide?
Sure.
Oh, okay. So that was the last slide. Okay. So I do want to say some more things about guardianship. One big question is, why do people want guardianship? And really, each case is different. I have clients who just, their child is not. So one thing is we do guardianship for an adult. So once their child turns 18. We have clients that want to start that process as soon as possible. They're coming to us, maybe their child is 16 or 17, but they just want to get the ball rolling, and they just want to make sure that they have guardianship as soon as their child turns 18, so that their role in being their child's main decision maker, it'll there's a continuity there, and they'll be able to keep making decisions as they've always done. Another reason why people want guardianship is because something has happened. So maybe some of the people listening can attest to this, but there's sometimes a gray area when you have someone with disabilities. Maybe they have to sign something, but can they read or understand what they're signing? And they just want, it gives them more peace of mind at the end of the day that they don't have to deal with that gray area, and they can say, as a matter of factly, and they have more clout, that I am the substitute decision maker because I have guardianship. I am my child's voice because they don't have one, or they're not capable of expressing themselves fully. So I'm here to help. Another part. Well, let me just take a step back. So when I talk about problems, sometimes they've come into a situation where they used to have access, for example, whether it's medical records, school records, financial records, they used to have access to their child's records. Now that they find when their child is an adult, there's a block there. They're unable to access that. And guardianship is one of the ways that we can circumvent that and make sure that, you'll still be able to do what you've always done. Okay. I think that's it for now, Ken.
Okay, that was excellent. What we find is that there's a common lifelong thread through the situation, and the clients that we have become lifelong clients, their life and the child's life. So, for example, I just spoke with a new couple of clients this afternoon. They have a son, he's on the spectrum, he'll be 8 in April, he's nonverbal. There's no other children. They do each have some siblings themselves, aunts, uncles of the child. But what they, we had to help them come to see is that we're starting right now. We'll be doing their wills and trust planning. That documentation is probably going to be good for 20 years. And we discussed the possibility of a Henson trust in the will of their parents for their share of an inheritance to minimize taxes and draw the grandparent into the process. So this is once we have this relationship, it's a lifelong relationship with them and with the firm. And it goes on, for example, until the child passes on. And it's this continuity is the common thread between what Diane has just said and what Peter will say in a moment. And that is that what she's talking about, for example, is how do you ensure that there's a continuity of care, a succession plan of care for the child, the person and property of that child. Often during their lifetimes, the parents get cooperation from doctors, but not always. And of course, they can be the ODSP trustee, so all right. And they can be the account holder for the RDSP that one day is going to be 700,000. All right, so things are fine now. But then they get to what we call the awkward age, where they're not going to die tomorrow. They've got another couple decades, but they understand mortality. And so what you do is you apply for legal guardianship, perhaps often to solve problems right now. You know, we do that, a lot of that too. People have been injured in car accidents and they're not competent and so on. But it's that common thread. What will happen? Who will care for my child when I'm gone? Who has legal standing to manage their RDSP? Who's going to apply for old age security and guaranteed income supplements when they're 65? And so what happens is the parents, plus often one or two siblings, of the child, if you're fortunate enough to have more than one child, then this is how you plan for the continuity of care of person and property. And what Peter's going to be discussing is more from the estate planning perspective. What will happen to my child when I'm gone? So he's going to discuss pensions, estate planning, wills, Henson trusts, insurance, policies to fund trusts, that sort of thing. But that's the common thread. So he's going to discuss how will the child be financially provided for when the parents are gone. So Peter, if you'd like to carry on, I'll just move to the next slide.
Yeah, happy to. Thank you. So I've actually seen this first slide deals with a few questions that have come up. And like Ken was saying, the concern of a lot of parents is what happens to my child when they're gone. Sometimes clients come to us saying, you know, my estate isn't going to be very large. How can I ensure that my disabled child is going to get the support that they need? One thing that comes up early on is pensions. So many forms of provincial and statutory pensions have these provisions that allow first typically a spouse to get 2/3 of it, but then if there is an adult dependent child, they typically qualify to receive 50% of the pension upon their death. So for example, if there's a pension amount of 60,000, an adult dependent beneficiary stands to receive 50% of that, or 30,000. And you know, they might lose ODSP, but it'll be outweighed by the pension that they receive. So that's one way that people typically don't realize their support will carry on after they're gone. And this is another reason why it's important to consider guardianship, like what Diane was talking about, because if that child is disabled to the point of being incompetent, then you'll likely need guardianship to manage where those funds go, for example, into an RDSP or however else you want to manage them. So that's just upfront one way that people might not realize that their estate is bigger than they think. Ken, if you don't mind moving to the next slide. But so I guess the bread and butter, the keystone of what we do is the Henson Trust. So historically, these are rooted in a desire to protect disabled beneficiaries' government benefits from inheritance funds. So as Ken mentioned, there are asset tests and annual income tests for government benefits. For example, the asset test is $40,000. You can't have more than that. Well, if you stand to, or if the beneficiary stands to inherit $100,000, then that'll instantly disqualify them. But putting that or directing that inheritance into a Henson trust out of the reach of the beneficiary protects those government benefits, because whatever's in that trust doesn't count towards that asset test. So to establish a Henson trust, there are three critical elements. You have absolute discretion, which means that the trustee has final say and the beneficiary has none, formally speaking. There's no vesting, so the assets in that trust never really belong to the beneficiary. They can be spent for their benefit or even sometimes given to them, but they never vest in that beneficiary. And not most importantly, but another element is that there's no even-handed rule. So usually trustees are under an obligation by law to exercise an even hand between beneficiaries. But this is specifically rebutted in the case of a Henson trust, meaning that all of the funds in that trust can be used for the benefit of the beneficiary without regards to any residual or other beneficiaries under the will. So typically, the inheritance goes into a Henson trust, which is set up as an investment account, and it grows over time. Disbursements are made to the beneficiary over time as needed, or you can spend some of the capital for the beneficiary's benefit. So for example, buying wheelchairs or renovations or improving their quality of life. And those decisions are made by the trustee of the Henson trust. Sometimes that's your executor and estate trustee. Sometimes it's a different trustee. That would be something to discuss with us when you're making your plans. Another question that came up that I'm just going to answer now is that a Henson trust can receive property after it's established. And that includes real estate. So you're not necessarily limited to the funds that go into it right at death. And there are other benefits to a Henson trust. So again, historically, they're used to protect the government benefits enjoyed by the beneficiaries, but you can also use them to protect funds from debtors or potential spouses because it's never really the beneficiary's asset. And they're also not exclusively for disabled beneficiaries. So you can be used for situations where perhaps a child, you know that they wouldn't necessarily be able to handle $100,000 at once. And you'd rather have that put into this Henson trust out of reach of them to be administered or meted out to them by a trustee that you know will be able to do that reasonably. And that brings me to the last point about Henson trust. It is important to choose the right trustee because it is up to them to make sure that the beneficiary is provided for, that the disbursements don't disqualify the beneficiary from any government benefits, and just to look out for the best interests of the beneficiary. Ken, if you don't mind going to the next slide. So another thing that came up in the questions, and I'm going to address now, is this idea of the lifetime benefit trust. So these are useful in situations where the second to die has substantial funds in registered plans, like RRSPs or RRIFs. So you can roll over proceeds of the RRSP or RRIF into the lifetime benefit trust in the same way that you could roll these over to a spouse. So a lifetime benefit trust, to qualify as one, can only have one beneficiary, and that beneficiary has to be dependent on the testator due to mental infirmity. It doesn't necessarily need to qualify for the disability tax credit, like some other things that I'll talk about in a moment, but they do have to be dependent due to mental infirmity. And the other condition is the proceeds of the registered funds that go into this lifetime benefit trust have to be used to purchase a qualifying trust annuity for the lifetime of the child. So that annuity will pay into the lifetime benefit trust. And the main benefit of doing things this way is that the income is taxed in the hands of the beneficiary. And that's the key. Instead of the registered funds falling into the estate and being taxed along with everything else, they're rolled over and taxed at often a much lower tax rate in the hands of the beneficiary. And I think the next slide has an example that I'll just walk through about how that would work. So here at the top is a situation without a lifetime benefit trust, and then underneath that is a situation with a lifetime benefit trust. So say you have $500,000 in registered funds, in this case in an RRSP and a RRIF. So under the typical scenario, say you die at the end of the year and half of that is taxed. So you're left with $250,000 of that $500,000. With a lifetime benefit trust, you take that same $500,000, you buy, in this situation, a 20-year qualifying annuity. The yearly payments to your child out of that annuity will be just shy of $25,000. Then if you take into account these tax credits, the basic tax amount and the disability tax credit, so about $14,000 and another $8,000, what you're left with in taxable income in the hands of the beneficiary is just under $24,000. So that beneficiary is then going to pay around $526 in taxes per year, per per year. That's right. And if you extrapolate that over the 20 years of the annuity, you're paying about just shy of 11,000 in taxes. So what that means, if you look at the very bottom, what you're choosing between in this situation is either half of your registered funds disappearing to taxes, or paying 10,000 in taxes. So you're looking at the difference between, $250,000 in taxes or 10,000. And in that kind of situation, the choice becomes clear. And if you want to talk about that, it gets a little bit more complicated, obviously. And if you'd like to talk to us about that, we're happy to talk about it. But just be aware that if you have a significant amount of your estate in registered funds, this is something that you should look into. This is just another example. You'll get these slides if you want to. It'll walk you through another scenario, but that's lifetime benefit trusts. I won't go too much into detail on this slide because there is quite a bit you could say, but there are a few things you should be aware of. So when you are establishing trusts, there are various, maneuvers is a word for it, to minimize the tax that you pay on these trusts. One of them is to ensure that when you're filling out your tax forms, there's a box where you can check off that the trust is filing as a qualifying disability trust. Basically what this means is that the trust is taxed at a graduated rate instead of at the highest marginal rate like non-QDT trusts. So that's something to be aware of. And in that situation, at least one of the beneficiaries has to qualify for the disability tax credit. There's also the preferred beneficiary election, which is kind of analogous. The trust can elect a preferred beneficiary. That beneficiary has to qualify for the disability tax credit and be dependent on another person because of mental or physical infirmity. Making this election means that accumulating income in this trust, again, is attributed to the beneficiary, which has the benefit of being taxed in their hands rather than being taxed in the trusts. So that's another thing to keep in mind. And last thing I'm going to mention here is under certain circumstances, real estate held in a qualifying disability trust might qualify for the principal residence exemption, which saves you paying capital gains tax when it's ultimately sold. So that doesn't necessarily benefit the beneficiary when they're alive, but it is a valuable planning strategy because when they pass away and you're disposing of that residence, those savings get passed on to the residual beneficiaries because you're not giving up a big chunk of that to taxes when you sell it. So that's another thing to keep in mind. Ken, if you don't mind moving the slide. So this is the last thing I was going to talk about, and it sort of bookends what I was saying at the beginning. Sometimes clients will come and they say, I'm worried that my estate isn't really going to leave anything for my child. Another way to think about that, and this is might be self-evident, might not be, is life insurance. So you can use these to top up or even fund an otherwise empty estate. And I say that because I'm actually in the process of helping a client who came to us, and their estate, as it was, is essentially insolvent. There's nothing in it. But they did have an insurance policy for $1 million. So this is a way that you can essentially fund your child's inheritance without necessarily having the cash on hand, which might typically come to mind when you think about, my estate. So there's an example here on the slide where we're looking at a female, age 50, non-smoker, life expectancy of 35 years. So if she purchased universal life insurance that would pay out $100,000, the monthly payments would be about $115, or about $1,400 annually. And one way to think about this is that it would take her 72 years of saving $1,400 a year to come up with $100,000. And with a 35-year life expectancy, that's almost twice as long, and she could never really do it. Doesn't really account for growth under investment, but this just illustrates the point that you can often look at life insurance as a way of subscribing to your child's inheritance. So again, I come back to the client that we're helping now. He didn't really have anything in the way of, not much in the bank account, but he had this $1 million policy, and now his son, who we helped him set up a Henson trust for, is set for life comfortably. So that's just another thing to keep in mind. And that's pretty much all I had to say about this part.
Oh, that's great. And just for fun, I intend to add another slide here because just for fun, last week, there's lots of simple calculators online. And what I did was I just never bothered to make this calculation until just recently. But if you take that premium and you put it into the calculator, and you take it as an annual contribution to an investment fund, and you invest it at 4%, and you leave it there for the 35 years of expected life expectancy, what you wind up with is that by the time the woman turns 35, she has saved and grown that money into 101,000. So really, basically, paying the insurance premium, you're giving it to the insurance company. Okay, they must be getting more than 4% because that's how they make money, right? They take your money and give it back to you with some growth, but mostly they get the growth. But obviously what's happening is the insurance company is receiving the premium, investing it someplace at more than 4%, and then based upon the overall life expectancy of when people die, they're obviously making more than what they're giving back, obviously. So, but I thought it was kind of, a nice congruence that that amount invested annually at 4% for 35 years is 101,000. So the only problem, of course, is what happens if you die tomorrow? Well, you've still got 100,000. So I just thought it was kind of fun. So let's see. So this is the questions. I'd like to invite Carmen and Alexandra, if they have any, to ask questions. You don't have to. And I see that we have a Q&A that still has an ongoing number of questions. I see there's about 26 to be answered. It goes up and down, so that the rest of the team must be answering a whole lot of questions. I remember one time we did one of these presentations. It was an hour and a quarter long, so 90 minutes, or 75 minutes rather. And Karen answered, I think it was 135 questions herself. So if you do have questions, after this is over, go and fill in the family evaluation form on the website. You can find it all over, but you could find it under contact on the top right as well. And it'll come to 3 of us. It'll be processed. We'll send you some reply. And if you have any specific questions about benefit increases or tax credits or wills or guardianship, when you call the office, you'll get the phone tree, and it'll say, if you're interested in this, press 1. If you're interested in that, press 2. So you're welcome to call, but it's most efficient to do it by way of email. And the best way to start is by filling out that form, because that's what we're going to ask you to do anyway. And this is how you contact us. I'll just leave that slide up there. So we're just approaching the 60-minute mark. And
Ken, do we have a few moments? Sorry, do you have a few moments to touch on some RDSP? I have about 30 RDSP questions. Most of them are in around the same idea about contributions and maximizing the grants and bonds. Do we have time for that tonight?
Sure. Can you tell me what people are asking?
Just a lot about the contributions. Like, what are the annual contribution amounts to aim for the 700,000 value end goal? Can we withdraw, like if you have a child that's life expectancy is not so long, is there a way to take out the RDSP earlier? How much should they be putting in to get the grants and bonds every year?
Sure.
Like those kind of.
Sure. The optimum contribution, if the child is 18 and based upon their ODSP income, the optimum is $1,500, because then you get a $3,500 grant, plus the child gets a $1,000 bonus, or bond, sorry. And if you simply do that for 20 years, 18 to 38, and then let it sit for another 10, so all the grants and bonds are vested, you can see here that if it was invested at 5%, which we have found is a realistic number if you have proper financial advice, then by the time the child is 60, it'll be about 700,000, and it'll pay out about 30 a year. And this is the calculation. You see, you do it. I picked date of birth year 2000 because that's when my son was born, and this age 6. This is an age that a lot of people might finally get to the disability tax credit approval form. For example, people on the spectrum might be identified at age 2, 3, 4, and perhaps around that time become approved for the disability tax credit. So then if you wait and you put this amount of money in each year, and we just picked this number, but 14,028, that's slightly less than ODSP, right? And you don't make any lump sum deposits, because the RDSP, you could contribute up to another 170,000 if you wanted to. You wouldn't get any more grants and bonds, but you could contribute it up until the child's 59th year, for that matter, but just before the year before they start to receive. So one would wonder why would you do that? But you know, we have situations where families over contribute in a sense, and there's the calculation. As far as getting the money out, what happens is either you simply follow the standard LDAP procedure to receive the payment spread out over 23 years at age 60, or you can do other things. For example, here is a shortened life expectancy. They're not expected to live more than 5 years. Now, this it's not really as useful as you might hope, because what it does is that the payments out are composed of the capital contributed, grants and bonds, and growth in proportion to what they are as a part of the whole fund, in proportion, and all withdrawals are in proportion too. So we have one of these files where the adult child is in his 50s, he has Down syndrome, he has dementia. What's happened is, because of the initially lowered cognitive level, the dementia, the loss of cognitive ability starts at a lower level. So what happens is people who start out at that lower level, as they age, have a reduced capability, just as many people do as they get older, but at a younger age. And he also has a shortened life expectancy. So what happened here is he's in a long-term care situation that the family's paying for, and it's about 50,000 a year. ODSP is only 14,000. So they withdraw 40,000 a year now, and they could have gotten this amount, $10,000, right? But 10 isn't enough. So because they need 40, even though the shortened lifespan situation is there, it's not that useful, because you can only get taxable portions, which is the non-capital portion of $10,000, which is, okay, it's $10,000 and you'll get a bit of capital, but you know, it's not really that useful. This deals with the holdback amount and plans where, in fact, most of the contributions are made by the family. If we have cases where someone dies, a lot of our work involves people who weren't our clients when they died, but their family is our client afterwards because they weren't our client when they died. And you can see that lots of people are not our clients and haven't put things in the right arrangement and do die. And so then we get the call. And sometimes it's from the person with the disability, but more often it's from the executor who knows that the person will lose ODSP if they give them the money, or a brother or sister often. So we exempt a lot of money in a lot of different ways, but it's for starts more expensive than just doing your will and trust stuff. And sometimes we can't, but normally we can exempt the money. And one of them, you know, that sometimes happens to fall into place is that the child would qualify for a disability tax credit, they would qualify for an RDSP, but they're now over 50 or over 49, and you can still contribute up to $200,000, up to this 170, or in fact a total of 200,000 to an RDSP up until the year in which the child turns 59. So sometimes we sock 170,000 of it into such a plan, which then sometimes changes the way money comes out. That's of course, that's an exceptional circumstance. The usual plan here is just a primarily government assisted plan. I think that's all I have to say about that, Karen. Are there any other significant themes that you're dealing with?
A bunch of Henson Trust questions that we try to answer as much as we could. No, a lot of it was RDSP tonight.
Okay.
Oh, maybe you can answer this question. I have 3 different people. Is some of these legal fees for their child, whether it be guardianship or benefit increases, etc., is that tax, like, can they put it on their income tax as like?
That's
like
a
a
logical.
tax expense?
It's a logical and not uncommon question, but no. The only expenses, for example, legal expenses you can write off are something where you're in pursuit of profit. Now, sometimes some of the advising that we do with respect to planning and estate planning and so on, some of it falls under the same rubric as carrying costs, as would be a paid financial advisor's costs. So sometimes carrying costs related to investments is deductible, but not guardianship, not wills and trusts, and so on. I think we're doing a pretty good job here. I think it's about time to wrap up. It's a balance. We have 395 people. We had about 440 at the high water mark, so we've still got a lot of interest. Carmen or Alexandra, did you happen to have any questions that we could answer?
I don't have any questions right now, but I just wanted to say thank you so much to you and your team for joining us and doing this webinar. And I encourage anyone to reach out to Ken and his team. And also, if you guys are interested in what we do at Asperger Society, you can reach out to us at the website Alexandra provided earlier, which is www.asontario.org. Or you can also email us at info@asontario.org.
Oh, that's great. Well, we've all had a good time, Carmen. I hope you have too. And I'm going to close off the event now. I hope everyone's enjoyed themselves and found things interesting.
Thank you.